Meeting to order. Welcome to meeting number 42 of the House of Commons Standing Committee on Finance, pursuant to Standing Order 108, Bracket 2. Committee's meeting on the subject matter of Bill C-19, an act to implement certain provisions of the budget tabled in Parliament on April 7th, 2022, and other measures. Today's meeting is taking place in a hybrid format pursuant to the House Order of November 25th, 2021. Members are attending in person in the room and remotely using the Zoom application. Per the directive of the Board of Internal Economy on March 10, 2022, all those attending the meeting in person must wear a mask except for members who are at their place during proceedings. I'd like to take a few moments to make comment for the benefit of the witnesses and members. Please wait until I recognize you by name before speaking. For those participating by video conference, click on the microphone icon to activate your mic, and please mute yourself when you're not speaking. Interpretation for those on Zoom, you have the choice at the bottom of your screen of either floor, English, or French. For those in the room, you can use the earpiece and select the desired channel. A reminder that all comments should be addressed through the chair. For members in the room, if you wish to speak, please raise your hand. For members on Zoom, please use the raised hand function. The clerk and I will manage the speaking order as best we can, and we appreciate your patience and understanding in this regard. I request that members and witnesses mutually treat each other with respect and decorum. I would now like to welcome today's witnesses from the Finance Department. Please note that today's witnesses are here to speak about Part 5 of the bill. Today we have a representative from the Canada Border Service Agency, Canada Revenue Agency, Correctional Service of Canada, Department of Citizenship and Immigration, Department of Employment and Social Development, Department of Finance, Department of Foreign Affairs, Trade and Development, Department of Indigenous Services, Department of Industry, Department of Justice, Office of the Superintendent of Financial Institutions, Privy Council Office, and Treasury Board Secretariat. Members, I will be suspending the meeting at approximately 5 o'clock or so to go in camera. It takes about 5 to 10 minutes to make that switch. And since we don't have opening remarks from any of our officials today, we are going to move right into rounds of questions. The first round, we'll start with the Conservatives, who are up for 6 minutes. Adam. Mr. Chambers.
Thank you very much, Mr. Chair. Appreciate all the officials joining us again today. I have some questions. I'll start with respect to the Competition Act changes that are proposed in the BIA. A couple questions on process and then some technical ones. With respect to process, was the Canadian Bar Association or other people consulted on some of the changes prior to them being in the BIA?
Yes. I'd say yes.
Okay, so we'll go to the next question. Is there a
Ms. Miller, do you want to? You have to unmute yourself. Yes.
Thank you, Mr. Chair. I was waiting for acknowledgement. I can speak to these amendments on behalf of the Department of Innovation, Science and Economic Development. The amendments that were proposed as part of the Budget Implementation Act are the product of ongoing policy dialogue with stakeholders and the Competition Bureau dating back several years, and the Bar Association is included in those conversations. They're also informed by public stakeholder positions, such as those provided to parliamentary committee hearings and the ongoing policy dialogue on this important topic in the public sphere.
Oh, thank you very much. So respect that there was some previous consultations. Is there a plan for consultations either on these changes or future proposed changes in the near future?
Once again, if I may, Mr. Chair, yes, indeed, the Minister Champagne has signaled his intent to proceed with further consideration of changes to the Competition Act as per the commitments in his mandate letter from the Prime Minister, and there will definitely be engagement with stakeholders and consultation as part of that process in the coming months.
Okay, thank you very much. Just a couple technical questions on some of the changes. On the wage fixing, is it the view of the government that this would apply to ride-sharing services like Uber? Would they be considered captured under this new proposed rule? or is that part of the consultation that will be settled?
Well, thank you very much for the question. As the Competition Act is a law of general application, it does not typically distinguish between specific business models or types of industries. The law applies broadly across the entire economy. So the enforcement of that act, if cases come forward, the Competition Bureau considers them in light of the general provisions and makes its determinations in the enforcement sphere in that way.
Okay, thank you. In the situations where there's a franchisee-franchisor relationship, who would be the employer, the ultimate parent franchisor or the franchisee?
Well, thank you very much for that question, Mr. Chair. And I would say, of course, it would depend, of course, on the specifics of an individual case, and it would depend on the business model of the participants in the case that was being brought forward at that time. So it would be very case specific.
Thank you very much. And with respect to some of the changes, amendments to Section 79 involving privacy, was the Privacy Commissioner consulted before these changes have been proposed?
Once again, thank you very much for the question, and Mr. Chair, the amendments have, as I've indicated, been informed by inputs across a variety of different avenues. So definitely comments that have been made by a variety of people to parliamentary committees, or in the public sphere, or in ongoing engagement between policymakers and the stakeholders in question. So comments that the Privacy Commissioner would have made in those contexts would have been taken into account, but there is not a specific consultation directly with the Privacy Commissioner on that specific amendment.
Thank you very much for that clear answer. In my remaining time, there are some other questions that I'll maybe table later, Mr. Chair, with the pleasure of the committee or your indulgence. I did note that we have some Treasury Board officials on, and I'd like to take this opportunity to reiterate a question that was asked the other day. I suspect maybe it's not answered yet. In my duty as on this committee, trying to understand the number of individuals that the government is planning to hire, both gross hires and the net full-time equivalent impacts of the budget measures through the forecast. This is important because we are in the tightest labor market in a generation, and people are concerned about wage price pressures. And if the federal government is intending to hire on the existing rates that it has over the last 5 years, it will create significant challenges for those in the private sector trying to access labor. So if there's an answer to that question, would love to have that now, but would appreciate an answer to that question in writing if it's not available today.
Treasury Board capture that? Do we have a representative?
Yes, we've captured the question and we'll transmit it to our colleagues. Thank you.
Thank you very much. And that's your time, MP
Thank you, Mr.
Chambers. And we're moving over to the Liberals. MP McDonald for 6 minutes.
Thank you, Chair. I just want to continue on in relevance to the Competition Act. Just a quick question, maybe back to Ms. Miller. And hopefully this wasn't asked previous, but was there any situations or cases that spurred the need for these changes?
Once again, I would thank the chair very much for the question. In terms of specific cases that are underway, of course, those because the Competition Bureau is an independent law enforcement agency that operates with some fairly strict obligations with respect to confidentiality. I, of course, would not be in a position to speak to any of those. However, certainly the department Department and also our colleagues at the Competition Bureau do follow trends in the marketplace, trends in business activity, and of course the public information on the cases that the Bureau publishes very closely, and use that, of course, to inform any policy options for Parliament's consideration.
Thank you. Going to move to Finance Department, and to make payments provinces to address transit shortfalls and improve housing supply and affordability. Will this money need to be requested, or is there a criteria to determine when it would come into effect? It's Division 4 and Part 5.
Yes, hello, Galen Kutchman, Director General of Federal Provincial Relations at the Department of Finance. So there are terms and conditions attached for the funding. As part of the bill, the funding could be spent based on terms and conditions that the minister deems appropriate. So the minister has communicated with provinces and territories, and has basically they've come to understanding the provincial and territorial governments must match the federal contribution. They have to allocate that funding within the jurisdiction to municipalities or regional transit agencies based on transit ridership, with flexibility for jurisdictions with little public transit, or to allocate according to the needs. Put funding towards transit operating shortfalls, transit capital, or housing. And provinces and territories must agree to accelerate their efforts to improve housing supply in collaboration with municipalities.
Thank you. Mr. Countryman, I come from a fairly rural province, Prince Edward Island, so I'm trying to envision, or maybe you can tell me how to envision, how do you differ between rural communities compared to larger urban centers in this funding?
Again, there was flexibility for jurisdictions, obviously, such as Prince Edward Island and other, where there's not large transit systems. So,
Appel au règlement, Monsieur le Président. La qualité du son est insuffisante pour...
If I may, Chair, the quality of the sound isn't insufficient for the interpreters.
On Mr. Countryman.
Oh, can you hear me now? Is that better?
And maybe slow down and see if we can hear a little better. Yeah, for our interpreters and for the members. Yeah, thank you.
Okay, I will endeavor to be more clear. So in the cases of small jurisdictions like Prince Edward Island, those jurisdictions have flexibility to allocate according to needs, as long as it's within the categories of transit or housing.
Okay, thank you. I'm going to move on to how will measures contained in Division 23, Part 5 help Canada utilize immigration to fill some of the labor shortages we currently see across the country?
Thank you, Chair, for the question. Phil Somagaveri with Immigration Canada. The amendments to the express entry system will further support Canada in being able to respond to basically a broader variety of labor market needs across the country by allowing the what are called rounds of invitation to be tailored to more specific attributes that would be assessed and recommended to the minister, for which the minister would relay through instructions. But it would give essentially more flexibility in the attributes possessed by the immigrants themselves that would respond to a wider variety of labor market or economic issues across the country. Thank you.
Thank you. And also, we have a lot that want to ensure permanent residency, obviously, citizens, and trying to create quality employment across the country for some of these. What opportunities are there via training through this source, or how do you do the criteria evaluation relevant to matching skilled workers with some of the openings or labor shortages that we have?
Thank you, Chair, for the question. Currently, these needs are assessed through the Express Entry Profile Builder, for which the candidate will relay various attributes, including human capital, education, skills, and work experience. And then those and in the presence of an offer of arranged employment. And then those would essentially be assessed and scored and be able to respond to the needs across the country in that manner.
Thank you, MP MacDonald. That's the time. And now we'll have questions from the bloc and MP Sainte-Marie.
Merci, Monsieur le Président. Donc,
Thank you, Mr. Chair. Once again, hello to all the officials of the departments here present. Thank you for being here, and thanks for answering our questions. My first questions will be on the Employment Insurance Act. So this is Division 26 and 27. So for Division 26, if I understand this correctly, the bill ensures that intergovernmental agreements that are already in place will be respected. That's Section 408 at Part 2 of the Act. But I'm wondering if these changes in Division 26 don't intend to circumvent that by, for example, withdrawing federal assistance now in place to, support employment, Canada Employment Insurance support. So could you tell me more about it? Tout à fait. Oops.
So the changes that are being proposed for related to Section 26 have to do with provisions that are in Part 2 of the Employment Insurance Act. And what we are looking to do is to modernize some of those provisions that are in the Act and that have been in there since 1996 to bring them in line with the current labor market needs. So to your question, whether this is an effort to pull to remove federal supports, that is not the intention. The intention is to make the framework more flexible so that we can serve more individuals to respond to the labor market pressures that we're all seeing right now. Thank you.
OK, merci beaucoup.
Thank you very much. More specifically, Section 403 seems to allow for signing agreements with any government or organization for the administration in order to ensure employment support. We know that agreements have been signed with most of the provinces when it comes to training labor. Could Ottawa, based on this, withdraw from that under 403? Could it offer funding and management to non-governmental organizations, even private organizations? I'm wondering about We Charity. I mean, that's the sort of thing I'm seeing here between the lines. Tell me more.
So there are agreements that are in place, like I mentioned, since the mid-90s with provinces and territories, and there's no end date for those agreements. Those agreements were signed, and like I said, they will continue. So that's certainly not the intention to end agreements. The Budget 22 did signal the government's intent to negotiate and modernize those agreements to meet the modern labor market needs. So those agreements continue to be in effect.
OK, merci. Je vais maintenant...
Thank you.
Very well, thank you. I will now go on to Division 27, still with regard to employment insurance. We're very pleased to see that the government will be supporting seasonal workers. Nevertheless, once again, this looks like a temporary measure for something that looks like it needs a permanent decision. The government seems to recognize this in its own budget. So the Minister of Employment has the mandate to set up, between now and the upcoming summer, a plan to reform employment insurance, given that the temporary measures in the program here come to an end in the fall. So we were hoping for a more permanent solution than what we see here. Unfortunately, not the case. Pierre Serré of the National Committee for the Unemployed, I'm speaking for him. So is a reform upcoming for the next budget? Will this be taken further down the road?
Thank you for the question, Chair. What I would say is that the government is, undertaking consultations on EI modernization, and that will inform changes to the EI system to better meet the current and future needs of workers and employers, including seasonal workers, which are an important group of workers, and that the government would release its long-term plan for the future of EI after the consultations conclude.
OK, merci. Le gouvernement ne semble pas.
Thank you for that. The government doesn't seem to have suspended the need for a balanced approach by the fund, especially after the pandemic. Any deficit, in fact, there is quite a big deficit given the COVID support that's been underway, and that could be disastrous in the future. So how's that being managed?
Thank you for the question, Chair. Just if I could understand, is this in relationship to the EI operating account?
Oui.
Yes, that's correct. That's what I mean.
Donc, c'est l'obligation pour la Caisse d'assurance emploi.
So the EI operating account needs to have a balanced budget. Has that been suspended? The government doesn't seem to have withdrawn that obligation, and the situation could become more serious given that the deficit is considerable since so many COVID supports were offered.
So I will turn to my colleague, Stephen Cote, on this question. Joel?
I'm sorry, I missed part of the question.
OK, je vais la répéter une troisième.
No problem. I can put it a third time. Thank you, Chair. The government does not seem to have suspended or withdrawn the requirement that the employment insurance operating budget be balanced, especially since the COVID supports used up so much of the budget. It could become quite an unbalanced budget, and this could lead to problems in the future. So how's that being managed?
I'm not sure I can speak necessarily.
Maybe I'll step in just to help on that. So there were, it was an announcement in Budget 2022 with regards to increases to the premium rate. And there are no proposed changes to the financing of EI in the legislation.
OK, merci beaucoup.
Thank you. Merci, MP Samari. NDP, and welcome to our committee, MP Gazan.
Thank you so much, Chair, and it's a real privilege to be on this committee today. I have big shoes to fill, as you all know. But my first question relates to Division 30 of the BIA, which amends the Canada Business and Corporations Act. It's my understanding that this section would establish a public and searchable beneficial ownership registry. And I'm hoping that officials will be able to describe what the changes to the legislation will accomplish in terms of getting us closer to establishing that.
Thank you very much. Thank you very much, Mr. Chair, for the opportunity to respond to this question on the establishment of a beneficial ownership registry. So the changes in the BIA are intended to be a first and concrete step towards establishing that registry. So there are things that the government is proposing to do immediately to make progress in the near term, and this would be obviously the ability for the information to be sent and held by Corporations Canada. That's the very important first step. Also, a very important step for the Corporations Canada to be able to hold on to that information and not immediately publish it, subject to the development of privacy and security protocols for the information. So we need to make sure that that information is treated appropriately. And and so that will be an intermediate step, but also to share it with appropriate enforcement agencies, FinTrack, or other entities that would be prescribed by regulation in the meantime, so that there is also that control over the initial distribution. The remainder of the amendments that would be required to fully establish the public and searchable registry require some consultation with stakeholders in terms of the specifics of implementation, and also in terms of the management of certain privacy considerations. So they will be consulted and returned as soon as possible.
Thank you. Thank you so much for your answer. I'm just wondering when the government will be moving to implement these changes with additional legislation, and can we expect to see next steps in the fall economic update?
Thank you. Thank you very much for the question. And I would like to indicate, unfortunately, I can't speak specifically to the government's future legislative plan for those amendments. But what I can indicate is, because of the accelerated timeline that has been announced as part of Budget 2022, that the work plan towards defining and proposing those amendments will be greatly accelerated. And so there will be consultation in short order, and then the finalization of work required to put them forward.
Thank you so much. I think it's no secret that the EI system is broken. We certainly saw that when the pandemic hit. Government on the fly had to create an entire new suite of benefits to get money to people who were unable to work in accordance to public health advice in a quick and efficient way. I think it's no secret that I've been pushing for a guaranteed livable basic income with Bill C-223 to make sure that everybody can live in dignity. And I will continue to push for that. But in the interim, though the EI process, we know, needs to be fixed. I've been in other committees where, officials working the area have called the system archaic. And I know there are consultations that have been ongoing about ways to modernize this dinosaur system. My understanding is that Division 32 of the BIA will establish an Employment Insurance Board of Appeal and limit the Social Security Tribunal. This has been a longstanding commitment of the government, and we in the NDP are hearing that these changes fall short of the commitments to create a truly tripartite and accountable appeal structure, and I'm hoping officials could speak to the intent of their amendments as well as what those amendments will actually do.
Good afternoon, Ruba Tapusi. I'll speak to that. The intent is, in fact, to launch a tripartite Board of Appeal, and it will include approximately the same number of members from GIC appointees, as well as members representing labor, employers, and members representing workers.
Thank you so much for that. GIS, Division 24, offers a technical amendment that will crisp up changes in the previous legislation government has made, ensuring that accessing pandemic benefits does not negatively impact recipients of GIS calculation. We saw that certainly in my riding with many seniors. This change had a huge impact on the lives of seniors, as I indicated in my riding of Winnipeg Centre, the third poorest riding in the country. Another issue that my office is being contacted about is the Canada Child Benefit, which is impacted by the same way the GIS is by the interaction of pandemic benefits in the calculation. I'm just wondering if any of the officials on the call could comment if they have been asked by government to draft fixes to this similar issue with the Canada Child Benefit that will have a huge impact on the lives of low-income families.
Hello, Chair. This is Kristen Underwood from ESDC. So the Division 24 refers to a change that was made around GIS eligibility for those who are getting the 75 plus increase. So it's not specific to the changes that you're talking about, but indeed those changes did go through this year. CCB is a separate issue and not part of these pieces, and we the officials who are on the line for those pieces of the GIS are not at liberty to, or we don't have information to talk to you about the CCB.
Thank you, and thank you, MP Gazan. That's the time, and we're moving to our second round members, and the Conservatives are up for 5 minutes.
Thank you, Mr. Chair. Yeah, I'd like to thank all the officials who are on for their service to our great country. I'd like to start with Division 4, payments in relation to transit and housing. I'm piggybacking on MP McDonald's work. Starting first, I'll just make a quick comment. The Member of Parliament Vancouver East has commented previously on the government's record on allocating housing, the national housing funding mechanisms fairly, and that BC did not receive it. So let's start with asking, in this maximum payment of $750 million, is there anything in this particular clause, and by the way, it's about 80 words or so for $750 million, is there any limitation to way to have it so that this is fairly allotted to each province and territory?
Hello, Mr. Chair. I'll respond to that question. So the funds for this measure will be allocated based on the formula already used for the public transit stream of the Investing in Canada infrastructure program, and it's calculated on a mix of transit ridership with a 70% weight and population of 30% weight.
Okay, so again,
that's how it's allocated across jurisdictions.
Again, going back to Mr. McDonald's point, that urban centers will be far more likely to receive these funds. Is that correct?
Because the primary focus was on transit, where there are urban centers, that the allocation was based on that.
Okay, but again, this can be, the minister has the sole discretion. Any amount payable under subsection 1 may be paid by the Minister of Finance out of the Consolidated Revenue Fund at the time and in the manner on any terms and conditions the minister considers appropriate. That is a lot of latitude, is that not, sir?
This is just how the legislation is provided.
Well, yeah, I understand you got a difficult job, and I'm not going to be making it more difficult than that. What I will say, though, is that I'm concerned, as MP McDonald said, about the fairness and allocation of this. I'd like to move to Division 12, and that's page 308, Prohibition of the Purchase of Residential Property by Non-Canadians Act. I've noticed that there was a number of loopholes in the budget, and then in the Budget Implementation Act, there seems to be a whole host of them. So I'd like to just firstly confirm that coming into force, Section 2371, Section 235, the enabling provision, comes into force on a day to be fixed on by the order of the Governor and Council. That ultimately means that Parliament can approve this, give royal assent, but the government can choose to bring it into force or not at its total discretion. Is that correct?
Thank you for the chair, Rob Sample of the Department of Finance. Thank you for your question. Yes, that's correct that the government would bring the prohibition into force at a later date on their choosing via an order in council.
Thank you very much. Non-application, so that's Section 5, subsection 1 does not apply if the non-Canadian becomes liable or assumes liability under an agreement of purchase and sale of the residential property for the day on which this act comes into force. So essentially, anyone who wants to purchase a property, regardless of the big holes in the exemptions the government has talked about for this, and will probably deal with through regulation, none of this matters if the government never puts it into force. Is that correct?
Thank you again for your question. Yes, the prohibition will only be applicable when the Governor and Council approves an OIC. To bring it into force. And what this provision does is...
That's okay. I don't need to know that particular part, sir. I'm going to ask quickly, just in definitions, under control has the meaning assigned by the regulations. So essentially, the control, I'm assuming you mean beneficial ownership. So how is precisely the minister going to be able to make an application to a court that someone has violated this? How will the minister be alerted to that?
Speaking on the provision of control, control of a corporation is additional policy that's being worked through now and will be brought through via a statutory instrument at a later date. Should there be a superior court or provincial court that finds that there has been a contravention to the prohibition, as you have outlined, the minister could then apply to the court for a judicial sale of the property. Thank you.
Thank you.
We're moving now to the Liberals and MP Zerwitz for 5 minutes, please.
Thank you so much, Mr. Chair, and I too want to thank all the officials for being with us today. So my first question is actually about the Copyright Act. There's a change under Section 6, or, well, it's 276 of the Budget Implementation Act, but it talks about a period of 70 years. Is the change from 50 years to 70 years? Can someone clarify that?
Yes, Mr. Chair, I would be happy to clarify that question. The change is from 50 years after the life of the author to 70 years after the life of the author.
Okay, thank you. The arts community has been asking for this forever, so I think they'll be very happy to hear about that. It actually brings us in line globally to where I think other countries are at. Thank you. My next question is it's on the Federal Provincial Fiscal Arrangements Act, and I believe it's under Division 6. And I believe that there is a total payment of $2 billion that's allocated here. Can I just confirm that that is for the backlogs in procedures and surgeries that are going to be sent down to the provinces and territories?
Yes, that is the purpose of the funding.
Perfect. And how will the funding be allocated? How will it affect the Canada Health transfer base?
It does not affect the Canada Health transfer base. It is a one-time top-up.
Okay, thank you. And the funding allocated is based on what you have listed between Sections A and Section M?
Yes, it's based on equal per capita allocation, the same that is used for the Canada Health transfer.
Okay, wonderful. Thank you so much. And then just getting back to the Division 4, in terms of the payments in relation to transit and housing, are there restrictions on how the provinces and territories allocate the funds within their jurisdictions?
The provinces and territories have been asked to allocate the funding based on transit ridership within their jurisdictions.
Okay, and that's the only restriction? That's the only criteria for them?
Well, they have to also match the federal contribution and then allocate the total of that funding based on transit ridership. And the funding is to be used towards transit operating shortfalls, capital, or housing.
Okay, wonderful. Then I'd like to head over to the Special Economic Measures Act. So it's under the Economic Sanctions Division. How will the proposed changes in this section, how will they help fight the illegal invasion of Russia into Ukraine?
Good afternoon. This is Lynn McDonald, Director General, International Economic Policy at Global Affairs Canada, and I can provide a response to that. Thank you for the question. So in response to the invasion of Ukraine by Russia, Canada and its G7 and other allies have taken numerous steps, including imposing a range of new sanctions measures. And in the context of these amendments, this has been a proposed change aimed at promoting accountability and ensuring that the sanctioned persons are no longer able to access their assets in Canada. as well as to return ill-gotten gains to those affected. So to that end, these proposed amendments will create the necessary authorities to identify, freeze, seize, and dispose of assets belonging to sanctioned individuals and entities. Happy to provide a bit more information if that would be helpful, but I'll pause here.
Sure. Just maybe continuing just on that line of thought. So how will the government identify the assets to be seized and forfeited?
So Canada and its allies in the task force, which is the Russian elites and oligarchs task force, which has been set up with allies in the G7, have all committed to taking measures along these lines and working together to track the assets of key Russian elites and proxies and to deny them the ability to hide their assets and benefit from assets in all of these jurisdictions. So the plan is for our government to work with domestic law agencies, other domestic departments and agencies, and our foreign allies to target relevant assets. And with that, that would be a connection through the amendments to allow the government to go forward and seize assets that are linked to a sanctioned person or entity seen as contributing to the grave breach of international peace and security, and in appropriate circumstances, manage those assets and then lead to the forfeiture of the assets through a court administered process. And then subsequent to that, determine if those, after the asset is forfeited, the appropriate disposal and repurposing of the assets, including to amend or go back to victims of the Russian invasion or contribute to the reconstruction of Ukraine. So these are a number of the steps that have been proposed through the amendments in Division 31.
Thank you so much.
And thank you, MP Zarowitz. And we're moving to the block. And MP Saint-Marie for 2.5 minutes, please.
Oui, merci. Ma première question.
Thank you. My first question is for Mr. Countryman. Picking up on the topic that was touched on by my colleague Julie. So at Division 4, public transit and housing, I would like to know how that will work with Quebec. We'll receive a transfer from Ottawa to Quebec of sums due to Quebec unconditionally, or will there be some negotiation to frame the use of the funds?
Oui, donc pour le Québec,
For Quebec, there will be a direct exchange with the Minister of Finance of Quebec concerning the program and the Government of Quebec's proposals to respect the aims set out for use of the funds. So there would be an agreement reached between the two levels of government. Thank you. That's clear. Now I will address Division 23, Immigration and Refugee Protection Act. So Division 23 of Part 5 amends the Immigration and Refugee Protection Act to, among other things, and there are a number of points here. I would just like to ensure, based on the Canada-Quebec Agreement on immigration that goes back to 91, do the provisions here at Division 23 apply or not to Quebec? They shouldn't, given that Quebec makes its own decisions about its immigration targets. I'd like to hear confirmation of that.
Thank you, Chair, for the question. That is correct. This is an area of selection, which is in the area of jurisdiction of Quebec pursuant to the Accord. Thanks.
Bon, c'est très clair. Merci beaucoup. Monsieur le Président, s'il me reste...
That's very clear. Thank you. Mr. Chair, if I have any more time, I'd like to share it with my colleague of the NDP.
Okay, great. So, MP Gazan, you have you have 3.5 minutes.
Thank you so much. That's very generous from my colleague from the bloc. Division 3 of Part 5 of the BNA repeals the Safe Drinking Water for First Nations Act, and this is long overdue and is a result, in fact, in response to a court decision that was made. That's very unfortunate that it had to go to court. I don't think anybody in this room on the committee would disagree that everybody has a right to clean drinking water. It's a basic human right, and it's a human right that's certainly upheld at the United Nations. I'm just wondering if any of the officials would be able to comment on why the repeal of this colonial act took so long.
Hi, Curtis Bergeron. Happy to respond to the question, Mr. Chair. Although I can't respond directly to why it took so long, I can say that it supports relationships and reconciliation efforts and is in direct response to concerns raised by First Nations, and I think demonstrates Indigenous Services Canada's willingness to act and support communities.
The court decision also indicated new legislation would be developed to replace the Act. And I'm just wondering if any officials on the line would be able to enlighten the committee on what types of consultations are taking place and who's being consulted.
Thank you again for the question. I would start by saying the Assembly of First Nations has been leading engagements with First Nations since about 2018. And that's through a number of forums, including water symposiums and water summits with Chief and Council and water operators and water experts. That was one area. The second area would be engagements through negotiations on the settlement agreement for the safe drinking water litigation, and thirdly, there was direct engagements around repeal just in March, and we're also working with Assembly of First Nations moving forward on legislation as the budget announced.
Just so I'm clear, you're the overarching organization that you're working with is the Assembly of First Nations. Any of the Inuit organizations, Métis organizations, or just Assembly of First Nations?
This is largely a First Nations led engagement, yes.
That's unfortunate, especially with what's happening in Nunavut right now with clean drinking water. Has the development of the new legislation begun?
Currently, we're working on establishing a framework that will help inform legislation, and that's with Assembly of First Nations.
And we can expect this new legislation when?
What I can say is, as was pointed out through the settlement agreement, it commits Canada to developing and introducing replacement legislation in consultation with First Nations by December 31st of this year.
Oh,
okay. Thank you, MP Gazan. That's the time. We are moving to the Conservatives for 5 minutes.
Thank you, Mr. Chair. So, Mr. Chair, first of all, I'd like to give notice of motion, and that pursuant to Standing Order 1082, the Standing Committee on Finance undertake a study of the Canada Revenue Agency's conduct regarding the decision on advanced pricing arrangements, and that the Commission of the Canada Revenue Agency appear for 2 hours at the beginning of the study, that the Commission of the Canada Revenue Agency appear again for 2 hours at the end of the study, that the Canadians for Tax Fairness as well as business and academic experts be invited as witnesses, that whistleblowers be invited to testify in camera, that the committee allocate 4 meetings to hear from witnesses, and that the committee report its findings and recommendations to the House.
Thank you, MP Stewart.
Now, with respect to this motion, Mr. Chair, the clerk will be getting it as well as a translated version of that, and I just wanted to put the members of the committee on notice and give them time for their consideration. I do want to apologize. I think I said excuse me once when I was reading it. You might have to strike that from it if that's possible.
Okay, thank you, MP Stewart. I was thinking it was the same as MP Albus's motion, but I guess it is a different motion. Yes. Okay. Yeah. Yep, we've got that.
It is a different motion.
Still have.
Must I read it again because of the? No. Okay.
No, we'll just take a paper copy. If you could just get it to the clerk, and then we'll have it distributed.
So hopefully the members will just put you on notice. That way, give you some time to think about it. And I do have some questions for the officials as well. 2 more minutes.
3 in a bit.
3 in a bit. Okay. Yeah. First question to the officials. Thanks for being here today as well. First question, how much money is government expecting to collect as a result of debt repayments on the initial CERB advanced payment?
Thank you for that question, Mr. Chair. As of right now, on the advance payment activity, there have been over 1 million people that have repaid from the people that have been identified. And I don't have a number of the exact money of the amount that's expected to be paid fully, but there is notices of debt being sent out now to the remaining individuals.
So government does not have an expectation or a target for what the amount is?
There's a target number of people that have been identified as having advance payments that are outstanding. That is, I believe there are 1.7 million in total, of which 715,000 have been sent out. But the total value, I don't have that number.
Can you get back to us on that with an answer?
Yes, I can check into that for sure.
Thank you. How much money is government expecting to collect as a result of debt repayments on the CESB payments for those deemed ineligible by the CRA?
My CRA colleagues are with me here now, but and they can correct me, but I can take a shot at that answer first, Mr. Chair, if it's okay. That work is not been underway as of yet, so there is an integrity process that goes underway in terms of determining ineligibility. That work has been delayed as a result of ongoing delivery of benefits and the Omicron variant, and so that work has not been undertaken yet.
Okay. Are expected repayment revenues from debt repayments on CERB and the CESB for those deemed ineligible included in budgetary revenues outlined in Budget 2022?
I can defer to my finance colleagues on this, but I don't believe there's any calculations with respect to expected payments that are included in the budgetary financial tables that are included in the budget.
Considering there are 1.7 million CERB recipients who have been told they need to pay back money, how much has CRA spent or expects to spend on administrative costs with respect to collecting those repayments?
So again, thank you, Mr. Chair, for the question. So in the fall economic statement of 2020, the government announced there was $260 million over 4 years for ESDC and CRA to increase the capacity to detect, investigate, and address the cases of fraud or representation related to emergency response materials. So that's the amount that's been announced.
Thank you, and thank you, MP Stewart. Moving to the Liberals, MP Chattel for 5 minutes.
Merci, Monsieur le Président. Merci à.
Thank you, Mr. Chair, and thank you for all the witnesses here with us today for your terrific work over the last few weeks. I would like to turn back to a question put to you by my colleague, Mr. MacDonald. Perhaps this is addressed to Mr. Countryman regarding transit and housing payments referred to at Part 5, Division 4. It's really not clear to me how rural communities will be able to benefit from this, how they will be provided with public transit. There's very little available, sometimes 2 bus trips available a week, public transit to bus, 1 in the evening and 1 in the morning. So what more can we do? Thank you for the question. It is the responsibility of each province to allocate funding based on their needs. We are asking provinces and territories to allocate the funding on the ridership of public transit with some flexibility provided for provinces and territories that don't have a very large public transit system in order to allow them to use the funds for housing, for example. Perhaps you could get back to us with a written example of what this would look like for the rural communities. I would like now to put a question to Ms. Miller. I know that a number of countries have now established lists, registers of beneficial ownership. I'm glad that we're now moving faster on setting up such a log for Canada. What counts, though, is the quality of the data in the register. Quality data depends on a very clear definition and application of the definition of beneficial ownership. I know that CAFE, which is a financial action group, has made recommendations to Canada and other countries, actually, about how to set up a proper definition and standards for defining beneficial ownership with specific recommendations for Canada. So what are the next steps to set up a register, not merely a register, but a good register, a quality register? Yes, thank you for the question. It will be a pleasure to give you an answer. The norms have already been set up in Canada, and they respect the international standards. It's been a few years now that we've been working on transparency in matters of beneficial ownership. For a number of years now, any companies under federal jurisdiction must collect information about beneficial ownership, so there are already criteria in the legislation defining beneficial ownership. Now what we need to do is, the step we're at is gathering together this information, centralizing. Right now, this information is available. Police officers, as of 2 or 3 years, can access this. Right now, the next step will be to collect it all in a single place. The benefit of that is ensuring that any companies that are being investigated will be easily picked out, and they will know. Mr. Simard? The chair is pointing out to me that I'm running out of time. Could you simply confirm to the committee that all the recommendations made by the CAFE group about beneficial ownership have indeed been included in the legislation? Yes, thank you. I'll do that. This will come in writing. Ms. Chatel, you...
Là-dessus, ce que je m'attends, c'est que
All right. What I'm pointing out, or what I think, is that I believe there are still some efforts to be made in the area of beneficial ownership, beneficial property ownership. Perhaps you could mention what the plan is to make use of all the recommendations that have been made. Yes, we'll do this in writing. Thank you. Thank you. MP Chatel.
Look at the time. We have enough time to do one full final round, third round, before we go in camera. And we have the Conservatives up first for 5 minutes. MP Fast.
Well, thank you very much, Mr. Chair, for the opportunity to ask a few questions of our officials. I also want to ask some questions on the beneficial ownership registry. Firstly, just to be very, very clear, right now the legislation that is before us under the BIA is not creating a publicly searchable or a publicly accessible beneficial ownership registry. Correct, Mr. Simard?
Mr. Chair, if you don't mind, we will answer this question together, as we are jointly responsible for implementing this commitment. The current amendments are step one of what will be required to enact a publicly accessible and searchable beneficial ownership registry. There are certain consultations that need to be undertaken with industry on the details of the implementation, and also some work that needs to be done, as the federal government must always do when collecting personal information on the privacy requirements associated with holding that data. So therefore, there will need to be a second set of amendments to fully implement the commitment.
Okay, could I get you to confirm that in writing to the committee?
Absolutely, Mr. Chair. We would be happy to follow up on that.
I am a little bit puzzled that in this case, our government is seeking to consult on this before implementing the searchability of this registry. But when it came to the Competition Act, the consultations are being done after the fact rather than before the fact, which is very disappointing. But again, back to the registry itself, I'm going to read you the provision of Section 433 of the BIA, which actually establishes the registry, and it reads, a corporation shall, on an annual basis, send to the director the information in its register of individuals with significant control over the corporation in the form and within the period that the director fixes. And I want to emphasize the words individuals with significant control over the corporation. Is that term defined anywhere in the BIA or in the Canada Business Corporations Act?
I can take this one, Jennifer. Yes, it's already defined in the CBCA, the Canada Business Corporation Act, pursuant to prior amendments, 2018, 2019 amendments I was referring to earlier.
Okay, and the director fixes the information that has to be deposited and the form in which it has to be deposited in the registry, correct?
Correct. This is a bit of a standard formulation in the CBCA. You will see it in other provisions. So, for example, the Corporations Canada, or the director, already corrects information on directors of the corporation, so it's a similar formulation.
All right. And going back to the definition, significant control over the corporation, will it actually capture the full extent of beneficial ownership that is often used in means that avoid compliance with the law?
So it's an international standard. So in the CBCA, it's the 25%. Significant control is defined as 25%, for example, of shares. There's lots of just different criteria. It's not only shareholding. So that was in the past we would define control just by owning shares, but it's broader than that. It's all forms of control. It could be through debt. It could be through other means. And the definition is fairly robust and complies with international standard. And again, it's been in place since 2018 because the first step was to have all corporations, all federally regulated corporations, know who their beneficial owner are. So right now and already, all businesses is supposed to have in their register information about who their beneficial owner is. What this step does is that it centralizes it. The director will collect it.
Okay, and just one last thought, and that is, it is really the expectation of Canadians that this be a publicly accessible registry. And I just want to make sure officials know, certainly we as a conservative opposition will be following this very closely to make sure that what we get at the end of the day is in fact a publicly searchable registry that Canadians can access. Thank you.
Thank you, and thank you, MP Fast. And now hearing from the Liberals, MP Baker for 5 minutes.
Thanks very much, Mr. Chair, and thank you to all of our public servants who are here with us today. I just want to reiterate what others have already said, which is our sincerest thanks for your service to Canada. And I, in particular, I know we have officials here from Finance and Treasury Board and Global Affairs and other departments, and especially the way government all of you have come together and worked incredibly hard to support Canada's work and lead Canada's work in supporting Ukraine as it tries to defend itself and the rest of us from Russia. So thank you for that. My question the first set of questions I wanted to ask relate to the special economic measures that Ms. Zarowitz was asking about a little earlier. And I wanted to ask if one of our officials could tell me what the value is of the assets that belonging to the sanctioned people and entities believed to be in Canada at this current time.
Good afternoon. Again, this is Lynn McDonald from Global Affairs Canada. And so currently, every person in Canada and Canadians abroad have to disclose to the RCMP the existence of any asset in their possession or control that they have reason to believe is owned or controlled by a sanctioned person or by an entity owned or controlled by a designated person or sanctioned person. And so that information is disclosed into the RCMP. At this present time, Global Affairs Canada is not in a position to have an accurate or up-to-date figure to share. That, as I mentioned, is within the sort of knowledge and competency of the RCMP.
Ms. McDonald, in perhaps I appreciate that those records are confidential, and because they are shared with the RCMP, and there'd be a whole series of considerations around as to why that information would be kept confidential. But just for the folks at home, my constituents who are watching or others who are interested in this measure, I'm very interested in this measure, and I think it's an excellent measure. But I think a lot of folks are curious about what the impact would be of this measure. I mean, you spoke earlier in response to Ms. Zarowitz, Minister Freeland, when she was before the committee, spoke about why these measures were put in place. And in part, it was about, at least in my mind, it's partly about making sure that those who are responsible are punished for what they've done in supporting Russia's war on Ukraine, but also to ensure that we have the resources to help, as you pointed out earlier, Ms. McDonald, support the victims of this war and to help rebuild Ukraine. And so I think a lot of people are interested about the impact of this measure, and the impact, of course, depends a little bit on the amount of assets that we are going to be able to seize. Do we have a ballpark sense of that? I'm not asking for the data shared with the RCMP. I'm thinking more broadly, are we talking about tens of millions, hundreds of millions, billions of dollars, order of magnitude? Do you have any sense of that?
I regret that I don't have that type of ballpark figure to disclose at this point in time. What I can say is that the measures are aimed at giving the government the opportunity to seize and, where appropriate, forfeit assets that would include, for example, financial assets like cash and securities, or non-financial assets such as real property, other tangible assets. There are, a great number, as parliamentarians will be aware of individuals that Canada has sanctioned, and entities pursuant to the CIMA Russia regulations. It's not clear that all of those individuals would have assets based in Canada. As I mentioned, it would be through the operation of the obligation and duty to disclose that Canadians and Canadian financial institutions would disclose to the RCMP when they're aware of those assets being present. So it will be a combination of those, and also, I think, an assessment made as to whether the appropriate evidentiary basis can be established that's set out in the amendments to ensure that the government could proceed with the seizure and then the forfeiture order. So certainly the opportunity is now there through the amendments, but in terms of providing you with a ballpark figure, I regret that I'm not in a position to do so this afternoon. But certainly the groundwork is laid through these amendments.
Thank you for laying that groundwork. Thank you.
And thank you, MP Baker. Moving to the block, and MP Saint-Marie for 2.5 minutes, please.
Oui, merci, Monsieur le Président.
Thank you, Mr. Chair. A brief comment. Of course, my question after the comment will be of a more political nature, given that this is a comment and it might be directed to the Minister of Finance or the government. But given that they aren't present, I will nevertheless ask the officials of the Finance Department to give me something of the logic behind this. This has to do with the 221 pages of this document to be studied between now and the end of June. And we can see that we're studying Part 5. It's really disparate. A number of topics here. As I understand it, this should be the implementation of the entire budget. Section or Division 18 is legislation in itself. on the Civil Lunar Gateway Agreement Implementation Act. This is international legislation, space legislation, how Canadian law will take form in space. So what's the link between this and the budget we've been looking at? And the next section is even, it may be the most surprising, Section 19 here. This has to do with detention and corrections, the use of detention in dry cells in cases where the institutional heads have. Anyway, it's why are we studying this? The contraband is being carried out and might be carried out within the inmate's body and so on. So why is this doing here in a budget where we're discussing so many other things at once?
Je demande aux hauts fonctionnaires
I'm asking the officials whether there's any technical logic to including so many things at once, or is this a political approach to ensure that there are less things are voted on within the House? Is this a Minister of Finance political move?
Of course it is.
Thank you, Chair. This is Jason Wood from the Canadian Space Agency with respect to Division 18. So I'm not in a position to speak to the rationale behind the composition of the Budget Implementation Act. I can, however, speak to the economic benefits related to the implementation of the Lunar Gateway. So the Gateway itself will generate 600 highly skilled jobs across Canada and contribute $71 million annually to Canada's GDP. I can also speak to the timeliness of putting forward this legislation in terms of needing to be able to ratify and fully implement the treaty with the United States that enables us to implement the Gateway Agreement. Currently, it is being provisionally applied, so most but not all of the agreement is in place, and it's necessary to move forward swiftly with this implementing legislation in order to achieve the economic benefits that I mentioned earlier. Thank you.
Thank you. Merci, MP Sainte-Marie. And now moving to the NDP and MP Gazan for 2.5 minutes.
Thank you so much. I asked questions about water, particularly relating to Nunavut. Part of the reason why is we know that the federal government wastes between $500 million to $1 billion a year fighting Indigenous peoples in court. We know that there was an allocation given to Nunavut, probably not enough to rectify the problem, huge waste of taxpayer dollars. But I'll leave it at that. But today's the National Day of Awareness for Murdered and Missing Indigenous Women and Girls. When I ask questions in the House about where things are at, this current government usually defers to the 2021 budget because, as we know, there was zero budgetary allocation in this budget to deal with this crisis of violence. I'm wondering if any officials online can tell me how much of the 2021 budget that was allocated has been spent to date. I take that as a no, or is there somebody able to answer that?
That can answer that, or at least take the question and venture to find the answer for the member?
Yeah, I think I'll leave it at that. And if you could please send that in writing. I have put forward an order paper question. I'm still waiting for a response. I say that because, we're not really seeing movement on the ground, and I can't seem to get any sort of indication on what's been spent or what the plan is. And as everybody knows and certainly appreciated the support and solidarity in the House of Commons today from all parties, solidarity only goes so far as action. I'm not seeing any action. So moving to a different area, one of the things that the pandemic really highlighted was the necessity of paid sick days. We know people are going to work sick, and they should be able to stay home and get well, especially with what we saw during the pandemic. I was pleased to see the inclusion of 10 paid sick days in Division 29, but I'm wondering if officials would be able to walk the committee through what the changes in this section will do. Thank you.
Good afternoon. I'm Zia Pu. I'm with the labor program at ESDC. I'd be happy to walk you through the key changes. So basically, there are 5 key things, including in BIA 1. What they're doing, I'll just give you a general overview, is that they're basically in response to some amendments that were made during the legislative process for Bill C-3, which happened in the fall of 2021, and also stakeholder feedback that we received in March. We did consultations on the implementation of the paid sick leave provisions and on the regulations. So the first key point is that it would simplify how employees earn paid sick leave days. So stakeholders have told us that the rules setting out the rate at which employees earn their days of paid sick leave are complex. So what it actually does, it's what the rule was that you would earn 3 days of leave after 30 days of employment, and then you would need to wait another 60 days before beginning to earn additional days, but always for up to 10 days per year. The proposed amendment would remove the 60-day period, so it would make it simpler. The earning model would be simpler for employees, employers, and for the enforcement. The second part is that it would align the requirements for the provision of medical certificates for paid and unpaid sick leave. So Bill C-3, which received royal assent in December, create a misalignment between the requirements for medical certificates under the Canada Labour Code for paid and unpaid sick leave. So it was basically, it was 5 days for paid sick leave, and it had to be 3 days for unpaid leave. So if the proposed amendment is adopted, employees would be entitled to request a medical certificate if the leave of absences are 5 days or longer, regardless if it's paid or unpaid. The third key point is, as currently drafted, employees whose employers change as a result of a transfer of business or contract retendering process could lose their earned days of paid sick leave despite working the same job. And that is inconsistent with other parts of the Canada Labour Code, like annual vacation. So the legislation would.
Sorry.
Because
Go ahead.
We've gone way over.
Okay, thank you so much.
Yeah, and maybe Ms. Pruill, you can send the rest of that response to the committee. That would be great.
We'll do so.
Thank you. And we're moving to the Conservatives for 5 minutes. MP Chambers.
Thank you very much, Mr. Chair. I'd like to return to some of the process questions with respect to the Competition Act changes, and just for clarity. Will future consultations be on the interpretation and how these new provisions will be applied, or are they relating to new changes that have not yet been proposed? So wondering if industry will be consulted on these changes and how they'll be interpreted.
Thank you very much for the question. And Mr. Chair, the consultations will be forward-looking consultations. So they will be on the broader matter that was outlined in the Prime Minister's mandate letter to the Minister of Innovation, Science and Industry. So we'll be looking at some of the broader questions related to the function of the Competition Act in today's digital society and economy, as opposed to the changes in the BIA.
Okay, thank you very much for that answer. I, full disclosure, asked the Deputy Prime Minister to review Competition Act, and so I was welcome to see some of these discussions in the budget and look forward to the consultation. But where I think I'm having a bit of challenge is, we had consultations with industry before some of these changes are proposed. Now we have proposed changes in a budget bill that is going to be rushed through Parliament, and industry now does not appear to have a consultation period on these proposed draft legislation changes. So, Mr. Chair, I would ask through you and the clerk given that these changes are significant, and we have also changes to the CBCA, I think we should be inviting the minister to appear. Probably unfair to ask some of the officials the questions that we have, but the Minister of Industry should come to this committee. These are very significant changes. And frankly, if industry is not provided the opportunity to consult on these proposed changes, I think we'll have a problem passing this legislation in the speed in which the government would like to pass this legislation, because I think we should be then changing this committee into doing the consultations that the government has failed to do on the proposed changes. So that is something I think we need to be very careful about. I'm open to some suggestions if we want to bifurcate or separate the bill so that we can do the proper consultations and add these into the budget bill changes that have been reviewed by industry and added into the budget bill in the fall. Maybe I'll be open to that. But I think we'd be very interested to hear from industry on these proposed changes at this committee. And so I have some additional technical questions. I won't bore the committee with reading them out into the record now, but I will submit them through you so that we can get them answered. My request to our industry officials, who I think have been great today with giving us some clear answers, is that we need answers to these questions before our industry partners come to testify before committee so that we can test those answers with our industry partners. So that will be very important for this committee. And perhaps in my remaining time, a clarification. In February, there was a notice provided about changing the Excise Tax Act with respect to digital asset companies and miners. I did not see changes in the budget bill with respect to input prices. Can I just get a clarification that any changes are actually not in this budget bill but will come in the future, or is there also planned consultation with industry on those changes? Probably a finance question. Mr. Chair, I'm happy to have the finance officials follow up in writing, and I can also follow up with the parliamentary secretary with that as well.
Okay, so that's being directed to finance, but it could be any one of the officials.
Well, whoever has the appropriate authority, I believe that would be finance with the Excise Tax Act changes. So okay. We'll leave it there. And Mr. Chair, I'll yield to you my last 10 seconds. I know you've been generous in previous rounds.
Okay.
Thank you.
Thank you. Thank you, MP Chambers. And this is actually our final question. Are we going to Liberals? MP McDonald for 5 minutes.
Thank you. I'm just going to follow up on Mr. Chambers. I'll take a little different approach, but obviously the officials talked a little bit about the consultations, but I guess what I'd like to know maybe from the officials, and maybe it's Ms. Miller if I remember correctly, that how will the amendment benefit businesses, workers, and consumers?
Well, thank you very much for the question, and Mr. Chair, I'd be happy to answer these questions as they pertain to the Competition Act. Generally speaking, the Competition Act is, as some of you probably are familiar, a law of general application that really aims to encourage a competitive economy where players are acting in predictable ways that encourage competition. And competition, of course, benefits consumers in a variety of ways. It produces certainly lower prices often when there is strong competition in a sector. It also leads to competitive intensity and innovation between competitors, so improving the services, the goods that are offered to consumers as well. So looking at prices and also at the quality of offerings. When it comes to benefits to workers, of course, again, a strong Competition Act, including some of the amendments that are being proposed around looking at stronger conditions around wage fixing and no poach agreements that creates a more competitive marketplace for those workers' labor as well. So it not only offers them ideally more job opportunities in more successful and growing companies, but particularly offers them some protections through these specific amendments as well.
Thank you. And just further on that, is there best practices that you're looking at relevant to this, along with the consultations that you're providing?
Certainly, and Mr. Chair, I'd be once again happy to clarify that with respect to the Competition Act. The part of the work towards developing any potential set of amendments really does look at what's going on internationally and looking at ways in which Canada's current system compares. It's not always the case that another country's system is in fact the best answer for Canada. It's important to be informed by these systems, but ultimately the Competition Act and its administration in Canada depend on, cases that have been previously investigated and ruled on. They depend on the behavior of players in Canada. They depend on the particular qualities of a market or a regional economy. And so therefore the amendments always do have to be specific to the Canadian context, but certainly informed by international best practices.
And is there consideration for further reforms to the Compensation Act as we move forward?
Certainly, Mr. Chair, again, I'd be happy to answer that question. The government has committed to undertaking further work to consider the place of the Competition Act and what further reforms might be considered. That will be the subject of further engagement and consultation in the coming months, as there is a commitment for our minister in his mandate letter accordingly.
Thank you. I just want to go back to the $2 billion in healthcare funding. I know my province is receiving about $8.5 million, and I just want to follow up on Mr. St. Marie's relevant question, I guess. There's always been issues and discussions around when funding is allocated, what that funding can be used for. Is there a specific criteria around this that ensures that the funding allocated to each province is going to be used for its purpose?
Thank you for the question. Just to clarify, this is with respect to Division 6 and the $2 billion for the one-time top-up for the Canada Health transfer?
Yes.
Okay, so the funding for that is being transferred to each province and territory. And the purpose of the funding is to support them in reducing backlogs created by the COVID-19 pandemic. And it is the responsibility for each province has their own ways to allocate that funding to address that need, and it'll be up to PEI and other jurisdictions to do so.
Okay, thank you. I just want to move back to a couple of questions, or possibly one if. Oh, I guess I can. Thank you.
Well, thank you very much, MP McDonald. Yeah, and thank you
I was on a roll, Chair.
Yeah, you were on that roll, and we want to thank all of our officials that came before us today to answer the many questions, and those that they will follow up with for the members and the committee. So thank you very much on behalf of the committee, the clerk, the analysts, the interpreters, everyone for the hard work that you do. Thank you so much. Members, we are now going to suspend as we go in camera.
you.